Louis Vuitton and MilaTextiles are going at it over the coral reef bags that were just showcased for spring-summer 2027 because, according to MilaTextiles, it seems to be that Louis Vuitton may have ripped off the style. But let's really get into the controversy and talk about the legal realities that are associated with it so that we can kind of have a clearer picture as to what's going on here. So let's get into it, shall we? Hello everybody, my name is Ivan Francis Wilbanks and I'm an attorney who's been practicing in the state of Georgia in the United States for the last 7 years and also is barred in the Commonwealth of Pennsylvania, but also I'm a fashion enthusiast and I follow it very, very closely. So if you like this sort of topic or subject matter, please hit that like, share, follow, and subscribe button for more content just like this. But let's jump into it, shall we? Because Louis Vuitton and MilaTextiles are going at it, and Instagram has been lit up over this discussion. So exactly what is going on, you may be asking? Well, Louis Vuitton just recently showcased their coral reef bags for spring-summer 2027's menswear collection, and in light of that, a lot of people and spectators were very surprised because the bags, as beautiful and opulent as they are, look very similar in style to another artist on Instagram. You see, another artist and designer, MilaTextiles, is very well known for embroidery and also beaded embroidery specifically. And so you can see that in Instagram, MilaTextiles showcases often that they can embroider a tie, they can embroider a mask, they can embroider any accessory seemingly with these beautifully gorgeous designs that are made and constructed out of seed beads and embroidery thread. And you can clearly tell that there's a lot of detail that goes into each of the pieces, and also there's a lot of time that goes into each of the pieces as well. The recent claim is that Louis Vuitton ripped off MilaTextiles' style in relation to the current bags that were produced. And the reason why a lot of people are claiming that is because of the similarity in style itself, in addition to the fact that there is a large degree of popularity and virality that came out of MilaTextiles presenting this particular design that now seemingly just cropped up out of nowhere for Louis Vuitton's collection. But now here's a bigger question. Is it that design and style alone can be copyrighted? And the general answer is actually no, unless it is very specific and readily attributable to a single designer or a singular source. Generally speaking, a style cannot be copyrighted because normally with styles, they include common elements that may be seen through other designs or other designers, or the style itself could have no original origin because of the fact that based off of the way how the style has been developed over time, there's no clear way to trace it back to an originator. So speaking about embroidery specifically, embroidery has been around for so long, for thousands of years, that it's really impossible to trace it back to a singular style. In addition to that, embroidery has been in part of the human history for so long also that each individual culture has developed their own tradition with respect to embroidery design and necessarily bead making as well. So as a result, it's really hard to say for sure that a style can be copyrighted and applied to this particular situation. There is a bit of a caveat to the rule, and the caveat to the rule is that in the event that you have beading patterns or embroidery patterns, similar to how you would get if you were to open up, a McCall's or open up some sort of guide that shows you how to go stitch by stitch, those may be copyrightable. And the reason why is that if you're showing a stitch by stitch guide on how to create something, or it is a bead by bead representation of how to arrange the beads to create a specific style, then at that particular point, because it has been reduced down to a written medium, the author is able to hold a copyright on the written work. But the work that is produced from that written work may not necessarily be readily copyrightable because, again, it can be produced by anybody and re-replicated by anybody. Now, some people may be wondering, okay, well, copyright may not be applicable and probably not a trademark, but what about a patent? And a patent could, keyword could, possibly be applicable here. But it's important to realize, number one, I'm not a patent attorney and that it requires a separate bar license. And number two, I'm just going to talk about based off of what I see based on my own research here in this particular field, because the answer to the question is yes, embroidery actually can carry a patent, but the patent is going to be more so related to the technicalities with regard to the manufacture and the creation of the item in question. So for instance, there's a patent that we have here from the 1880s. There's another patent that I have here from 1907. And then there's even patents as most recently as the 1960s with regard to 3D embroidery. So with respect to patents with regard to embroidery, they do exist. They fall into the realm of what they call a utility patent. And a utility patent is very technical, but often those are used in situations where it's chemical compositions or structural compositions that require scientific calculations to be provided. In that particular situation, then you can probably say that if the beading pattern was designed in such a way where it requires specific mathematical calculations, reasons, you could make the argument that potentially with a registration, there could be an infringement. But the issue here is not necessarily the matter of registration or a patent or even a copyright, because of the fact that, again, it is a claim that the style was ripped off of. And so, legally speaking, is there protections for style? Not necessarily. But it also prompts a bigger conversation about attribution. Attribution is something that is kind of not really in the realm of law necessarily, but we're talking about creative integrity here more so than anything else. Because while the law may not be able to provide a safeguard or a protection in this particular circumstance, because style is not readily copyrightable or able to be patented, creative integrity calls that attribution is the most appropriate thing to do when you are looking at an inspiration from another smaller, lesser-known artist and elevating their work to a global stage. And so, again, I don't necessarily think that this is necessarily a matter of just straight legality, but more so it's a matter of artistic integrity in addition to the legality. So in light of that, please leave your thoughts in the comments about whether or not attribution should be had in this case, or if you still believe that there is a legal claim to be had here. And again, if you like this content, please hit that like, share, follow, and subscribe button for more, and I hope to see you in the next one. Toodles.